Welcome, and this is One Timers, and we're going to go through wills today. And a couple notes about wills. Wills is a California-specific subject, and what that means is the call of the question will inevitably say, answer according to California law. There's only very few subjects that are based on California law: wills, community property, evidence, and California civil procedure. Professional responsibility actually is both ABA and California. But when you see a wills question, the call of the question in the essay will say, answer according to California law. Now, the three biggest issues in wills, what to expect on your bar, is going to be pretermitted or unknown child, formation, which is the first section, which we're going to get to in a minute, and revocation. The most important thing to do when you are doing a wills essay is keep in the back of your head the testator's intent, because that's going to be so important. You're going to have to discuss the testator's intent in some aspect on a wills essay. I can almost guarantee it. Okay, let's start off with section number 1, formation. Now, there's formally executed wills. So in California, a will may be formally executed. It may also be holographic, which means handwritten. For a formally executed will, it's pretty easy. Just use the mnemonic plus, which is a good way to remember it because it's so easy. We'll go through each element. The first one is the presence, and that's actually the most important element, is presence. And that means that the testator must sign the will in the joint presence of two witnesses. So the key is when the testator signs his will, when he if he acknowledges his signature, so he signs it by himself, but he says the two witnesses being present at the same time, this is my signature, or he acknowledges the will in front of two witnesses at the same time. So the most important thing is the most important aspect of the formally executed will is the joint presence of the two witnesses. Then we have lifetime. Well, the witnesses must sign during the testator's lifetime. Keep in mind that the witnesses do not have to sign in the presence of each other, and they do not have to sign in the presence of the testator. The thing that's the most important, again, is the testator must sign in the joint presence of two witnesses, or acknowledge the will or acknowledge a signature, either one. The next thing is understand. Well, it's rare, that element's almost never going to be an issue because it's rare that somebody signs a document that they don't understand what it is. I mean, how often do you sign something without even looking at it or without even knowing what you're about to sign? And the last thing is it has to be signed. So that means the will has to be signed by the testator. It can also be signed by a conservator pursuant to a court order. So the conservator has the power to act as the testator. We'll get into conservatorship in just a minute. Also, someone else may sign, another person may sign the testator's name, so long as the person does so in the testator's presence and at the testator's direction. So make sure that the testator is there. The testator has to be present when the person signs. Well, you're thinking to yourself, if the testator's there, why doesn't he just sign by himself? Think about someone who's got some kind of disability where their hand shakes and it's very, very hard for them to sign. Maybe like Chris Paul, they broke their finger and the cast is on, so they have no ability to actually move their hand. That's when you'll have someone else sign it. Usually your attorney or somebody like that, but as long as they sign it, in your presence and at your direction. So those are the formally executed requirements. Like I said, the most important thing, I'm going to hammer this home, is that the testator must sign the will, must acknowledge his signature, or must acknowledge the will in the joint presence of two witnesses. Now, if for some reason the will is not executed in compliance with one of the witnesses requirements, then the person who wants to admit the will into probate, that's the proponent of the will, must establish by clear and convincing evidence that the testator intended that would be the will. For example, let's just say that one of the witnesses signs after the testator dies. Well, in that case, you have to prove by clear and convincing evidence. Remember, preponderance is about 51%, clear and convincing is about 75%, and beyond a reasonable doubt is 90%. You don't need to know those numbers, but it's a nice way to keep them in your mind what clear and convincing means. And on the bar, you're just going to use the facts to support your point. I mean, can you produce clear and convincing evidence that at the time the testator signed the will, that the testator intended the document to constitute the will, even though it failed for one of the witnessing requirements. That's what you're most likely to be tested on if it fails to comply with one of the formally executed requirements. Okay, conservator, one of the most recently tested issues, and oddly enough, it hasn't been tested prior to this, and one of the reasons is because the legislature back in 2008 had stated that they wanted to make more laws that dealt with the conservatorship. I don't know the reasoning behind that, but conservators now. So what is a conservator? A conservator is a person who makes the decision for another. Generally, in order for the court to appoint a conservator or a guardian, the ward or the conservatee, that means what's going to be the testator on the bar exam, must be unable to manage their own financial affairs, or they're not able to provide for their own personal needs. But keep in mind, though, a conservatee, that's going to be the testator. It's going to be like the old lady, the 85-year-old man, the frail person who's about to die. Just because they have a conservator doesn't mean that they cannot make a will. So a conservatee might become competent to make some decisions, but able to make others. The standard is whether the testator, which is the conservatee, has the ability to understand the transaction. So you focus on whether the testator has the ability to understand the transaction. So ask yourself the question, is T mentally competent? And you're going to get into the elements of mental competence, which we're going to get into a little bit later. So that's what the conservatorship is. So keep in mind, it's important to note that a conservatee who is mentally competent has the right to make a will or revoke a will that has been made by a conservator. And the conservator does have the power to make a will so long as the court appoints the conservator to do so. Interested witness. All that means is that a beneficiary, one of the witnesses who signs, one of the two witnesses that sign, is a beneficiary under the will. When you are, California allows a will to be probated even though there is an interested witness, but there's only a presumption of undue influence. For example, I'm an attorney. Let's say my older brother and I are the two witnesses to my mom's will. Well, let's say I'm a witness to my mom's will. Well, there's a presumption that I procured it for undue influence, but let's say that she gives everything to my brothers and I equally. Well, in that case, we're easily going to be able to overcome the presumption, so there's going to be no undue influence. Now, interested witness, if one of the people who sign is an executor or trustee, you don't apply interested witness because an interested witness has to get a gift under the will. Now, you might say, well, trustees and executors, they get paid. Correct. They get paid for their services. They're not getting a gift. There's a difference. So when somebody takes as a trustee or an executor, that means they take in a fiduciary capacity and they're not considered an interested witness. So therefore, you don't have to even overcome a presumption under those circumstances. Holographic wills. The word holographic, all that means is handwritten, handwrite. So there's only two elements to that, and they're very easy. And this is actually extremely heavily tested, and it's such a slam dunk that you should be able to stuff this one. So, testator's own handwriting. The material provisions. What does that mean? That means that the gifts and the names of the beneficiary must be in T's handwriting, and the testator must sign the will. Of course, the signature could be their first name, their initials, even an X. I mean, personally, I sign my name like that 90% of the time. That's going to be my signature. True. That's good enough for the T's handwriting, the signed. The material provisions, so the gifts and the names. So if I write down, I give Ryan $10,000, that is a valid holographic will. That's it. That's how easy holographic wills are. Okay. And when you're going to see the fact pattern, it's going to tip you off really easily because it's going to say the testator handwritten or the testator wrote. I mean, wills can't be any easier. I'm telling you, it's got to be one of the easiest subjects on the bar exam. Codicil. What is a codicil? It's just an amendment. You could look at it as its will number 2. But all it is just an amendment to the will. For example, we have the U.S. Constitution and then we have the Bill of Rights. The Bill of Rights are an amendment to the U.S. Constitution. And if we were to rip up the Bill of Rights, we would still have the U.S. Constitution. Same with the codicil. So if we revoke the codicil, it doesn't revoke the will. Codicil is just an amendment to a will, and of course, because it serves the same purpose as a will, it has to be executed with the same required formalities. That means it must be either formally executed or it must be holographic. So a codicil is treated the same as a will. Technically, it's an amendment to it. And finally, choice of law. Rarely test it, but in most cases, what's going to happen is you're going to have somebody who lives outside of California execute a will in compliance with the laws of the state that they executed in, but it's not going to be in accord with California's requirements. But anyways, California says it's fine. So this is such it's so broad that more likely than not, it's going to become valid. In fact, it'll be valid on your bar. Okay, so choice of law. If you execute it according to California law, obviously it's going to meet the formalities, you're fine. Where T executed the will, let's say I go visit my family in Pennsylvania, and I go to a lawyer's office there, and I get my will done. And of course, the lawyer who's licensed in Pennsylvania, not California, knows about Pennsylvania law. So it's where T executed the will, which is totally fine. So if it complies with the laws of Pennsylvania, California will accept it. How about where T was domiciled when it was executed? Let's say that I live in Nevada, and I end up moving to California before I die, but I get older, I move to Nevada, and so I execute the will in Nevada where I currently live. And it's like, you know how a lot of people, when they get older, they move to Florida and kick over there. So the law is valid in California where T was domiciled when it was executed, and finally, where T is domiciled at his death. Just think about the deathbed where you write a holographic will. As long as it's fine in the state where you're domiciled at the time you die, California is going to accept it. So it's going to be very broad. Inevitably, you're going to end up discussing California law. As long as it's valid in one of it's the state that it was executed, the state where the testator was domiciled, or at death, or when it was executed, you're going to be fine. So it's very broad, not heavily tested. In fact, it's only been tested one time in the last 16 years. That's how often you're going to see it. And there you go. That's a wrap for section 1, formation. This is actually one of the most heavily tested sections, and it's that easy.